Contact us to avail the combo offer of General Studies and Public Administration optional with 20% discount.
Hello everyone, welcome to Lukmaan IS. In this series, we are discussing the previous year questions of UPSC Prelims exam, and today we are going to take questions from Indian Polity. Okay, so now let us see the topics that are important for the day. Okay, so we are going to understand some questions related to these topics. One question will be from right to privacy, second question will be from religious minorities, third question will be from government schemes, fourth question is taken from Office of Profit, and the fifth question is from 9th schedule of the Constitution of India. And all these topics are important from this particular portion of the prelim syllabus that says Indian polity and governance, constitution, political systems, panchayati raj, public policy, rights, issues, etc. So this is the part of Indian polity syllabus in the prelims exam. Okay. So now with this, let us take the first question for the day. This question was asked by UPSC in the year of 2018. Okay, just 2 years before UPSC has asked this question. Okay. So this question is with reference to a particular issue that was in news in that year for more than 6 months. Okay, it has been in news time and again, and the UPSC has framed a question on that particular topic. So now let us understand what was the topic. Okay, let us read this question. It says, right to privacy is protected as an intrinsic part of right to life and personal liberty. Which of the following in the Constitution of India correctly and appropriately imply the above statement? Okay. So when we talk about right to privacy as an intrinsic part of right to life and personal liberty, so with this respect, the Supreme Court of India has given a judgment in the Justice Puttaswamy versus Union of India case. Okay, so that Justice Puttaswamy case, okay, in the Justice Puttaswamy case, the Supreme Court of India has given a verdict in the year of 2017. And in that particular verdict of the Supreme Court of India, the Supreme Court of India categorically stated that right to privacy is an intrinsic part of right to life and personal liberty. Okay, and you know that right to life and personal liberty is there in Article 21 of the Constitution of India. And Article 21 of the Constitution of India is a part of the fundamental rights. Okay, and fundamental rights are mentioned in Part 3 of the Constitution, from Article 12 to Article number 35. Okay, so here if we see option C, this option C says Article 21 and the freedom guaranteed in Part 3. Definitely Part 3 of the Constitution of India talks about fundamental rights. Okay, and Article 21 of the Constitution of India is considered as the soul and heart of this fundamental rights. Okay, so this particular article is talking about the right to life and personal liberty. Okay, so Supreme Court of India has interpreted that right to privacy is also an inherent right under right to life and personal liberty. Okay, so that's why correct answer for this question is option C. Okay, so with this, now let us take another question for the day. Okay, so correct answer was option C. Okay, so let us take another question. This question was asked by UPSC in the year of 2011. Okay, so let us read this question. It says, in India, if a religious sect or community is given the status of a national minority, what special advantage it is entitled to? Okay, so you might have heard, like many of you fill the UPSC prelims paper. So while applying for the UPSC paper, you need to write your name, date of birth, and along with this, you also have to write about your religious, like a religious thing, like whether you are a general or you belong to minority and all. So like if a particular sect or religious, community is given the status of national minority, so what rights do they get in addition to general people? So this question is associated with that particular topic. Okay, so one thing here, it says that it can establish and administer exclusive educational institutions. Okay, so you might have read in the fundamental rights in the Constitution of India under Article 29 and 30 that talks about right of the minorities to establish the, educational institutions of their own choice. Okay, so like certain rights are given. These are known as cultural and educational rights. Okay, so like if a religious minority or religious community or sect is considered as a national minority, so they get those rights that are mentioned under Article 29 and 30. And under this, what they can do, they can establish their own educational institutions. Okay, so it can establish and administer exclusive educational institutions. This statement is correct. Okay, if this statement is correct, what we can do, we can eliminate option B. Okay, we can eliminate, because option B does not have the first, like 1 as the correct option, because here we have to find out the correct answers. Now let us take the second statement. It says the President of India automatically nominates a representative of the community of Lok Sabha. Okay, so this statement is incorrect. Okay, so like there is no provision in the Constitution of India that gives automatic right to a particular community, okay, for its representation in the Lok Sabha. Okay, so like general elections are conducted by the Government of India or by the Election Commission of India once in every 5 years, and under that general election, constituencies are delimited. Means like the constituencies are set. Okay, and in those constituencies people vote for the party that they support, and like a party that wins, they come to the Lok Sabha. But the thing is, no automatic, like President of India automatically does not nominate a representative. Okay, although the President of India has the right to nominate 2 persons in the Lok Sabha and 12 people in the Rajya Sabha. Okay, but the thing is, this religious minority or national minority do not get that particular right. Okay, so that happens under specific conditions, when President of India in his opinion finds that a person is has done something extraordinary in a particular sector. Okay, so that like his nomination into the parliament is helpful for the Indian society. Okay, is helpful for the political process. Okay, so this statement is incorrect. So if statement 2 is incorrect, we can eliminate some options. Okay, what options we can eliminate? We can eliminate option D over here. We can eliminate option D, that has 2. Okay, now we are left with option A and option C. Option A has 1 only, option C has 1 and 3 only. Okay, let us read the third statement also. It says it can derive benefits from the Prime Minister's 15-point program. This statement is correct. Okay, this particular statement is correct, that like this particular minority community can derive benefits from the Prime Minister's 15-point program. So this Prime Minister's 15-point program is a specific program that is designated to benefit the minority communities. Okay, so there are provisions in that particular Prime Minister's 15-point program. Those provisions are helpful for national minorities. So this is correct, although many of you may not be knowing about this particular Prime Minister's 15-point program, but like people who have read about it, they were able to answer. And there are many people like who have just guessed, like they were knowing the first statement right, they were knowing second statement is incorrect, but for third statement one had to take a calculated guess. Okay, so if somebody has ticked option C, so that answer is correct, and option A is incorrect, because 1 and 3 both are correct. Okay, in your free time you can search about Prime Minister's 15-point program and you will learn more about it. Okay, so with this, now let us take the next question for the day. Okay, this question was asked by UPSC in the year of 2010. Okay, so let us read this question. With reference to the Constitution of India, consider the following. Okay, number 1, it says fundamental rights. Number 2, fundamental duties. Number 3, directive principles of state policy. Okay, so like these are provisions. Fundamental rights are in part 3 of the Constitution. Okay, fundamental duties is mentioned in part 4A. Okay, part 4A in the Constitution. Directive principles are mentioned in part 4 of the Constitution of India. Okay, so now let us read this particular directive in the question. It says, which of the above provisions of the Constitution of India is or are fulfilled by the National Social Assistance Program launched by the Government of India. Okay. So now here we need to understand that the directive principles of state policy are those directives that this particular thing, like legislator has to keep in mind while framing a law. When legislatures are like making some law, they keep in mind these directive principles of state policy, and at the same time when executives are implementing those laws, they also keep in mind that like provisions of the directive principles of state policies are being implemented. Okay. So here they are talking about National Social Assistance Program. So under this particular program, the Government of India tries to give social assistance to people by giving jobs, okay, or like giving them like jobs so that like they can meet their daily needs. Okay, that's the thing. So under this particular thing, the Government of India is actually, okay, trying to implement Article 41 of the Constitution, and Article 41 of the Constitution is mentioned under the Directive Principles of State Policy, DPSP. Okay, DPSPs are mentioned under Article number 36 to 51 in the Constitution of India, and DPSPs are mentioned in Part 4 of the Constitution of India. So directive principles of state policies are those directives that the legislature and the executive keeps in mind while framing certain laws. Okay. At the same time, these directive principles of state policy were there before the Constitution of India was came into force. So in pre-independent India, when the Britishers were having their government, okay, there these directive principles of state policy were also known as instrument of instructions. Okay, these were known as instrument of instructions. Okay, and these instrument of instructions were those the instructions that were given to the Governor General and the governors. Okay, so that like while implementing certain policies or while framing certain policies, they should keep these instrument of instructions in mind. Similarly, after the Constitution of India was enacted, after India became independent, so these instrument of instructions took the shape of directive principles of state policy. So correct answer for this question is third statement. Okay, fundamental duties are not given effect by any law. Okay, so they are not directly given effect by any laws. These are those duties that the citizens are expected to perform. Okay, and at this point of time, the fundamental duties are mentioned in Article 51A of the Constitution of India. Okay, this is mentioned in Article 51A of the Constitution of India, and we have 11 such fundamental duties. Okay, so these are the duties that are binding on the citizens, that citizens should perform it. But like if a particular citizen does not perform any of the fundamental duty, in that case it is not justiciable, means like people cannot drag him into courts. Okay, so this is fundamental duties are not justiciable, and this particular law was not made to enforce some fundamental duties. So second statement is incorrect, and fundamental rights, most of the fundamental rights are automatically enforced, and for certain fundamental rights to be enforced, the government has to bring certain exclusive legislations. Okay, but this is not that particular law. Okay, so that's why correct answer for this question is option B, 3 only. Okay, 3 only is the right answer. So having understood this, now let us understand another question. Okay, let us take another question, and this particular question was asked by UPSC in the year of 2019. Okay, here before I read this question for you, you need to understand that there are certain questions in the prelims exam for which you need some prior information, means like you should have knowledge to solve that question. Okay, means like you should have knowledge about these statements, and there are certain questions, those questions specifically require you to answer those questions using elimination method. Okay, means if you are sure about a particular statement is correct or incorrect, using that one statement or two statement you can arrive at the answer. Okay, So in this question, to answer this question, you need to apply the technique of elimination method, okay? And using only elimination method, you can answer this question. Otherwise, those people who have read so deeply, okay, who actually know about the things, okay, very old things, they'll be able to answer, okay? But those smart people who know the elimination technique, they'll be able to answer this question. Let us read this question. It says, consider the following statements. The Parliament Prevention of Disqualification Act 1959 exempts several posts from the disqualification on the ground of office or profit, okay? So the thing is, many of you, like you are aspirants of UPSC, you might have started your preparation just now in 1 or 2 years. You may not be knowing about this particular thing, like, you know, Prevention of Disqualification Act 1959. It is so much old act. But, like, you know, this knowledge may be expected from a person who has public administration optional, because those people actually read about various, you know, laws of the government, and they read about various provisions, okay? But for general people, it may not be known, okay? But the thing is, correct answer, this is a correct statement, okay? If you don't know, but this is a correct statement. Even if you don't know whether it is correct or not, you will be able to come to the right answer. Let me tell you how. Second statement says, the above mentioned act was amended 5 times, okay? This is also very factual statement, okay? This statement is very factual. Many of you may not be knowing that, like, a particular legislation, very old legislation, how many times the government has amended. Many people don't know about it, okay? If you talk about third statement, it says the term office of profit is well defined in the Constitution of India, okay? So office of profit is there in the news multiple times, okay, every year, okay? Like, you will find multiple articles in the newspapers like The Hindu, in Indian Express, talking about office of profit. But the thing is, office of profit is not well defined. It is not defined in the Constitution of India at all, okay? Only the mention of office of profit we find in the Constitution. We do not find its definition, we only find its mention, okay? Means in the Constitution it is mentioned that, like, office of profit, but, like, they did not define what is office of profit, okay? So this statement is incorrect. Third statement is incorrect. If only you know that the third statement is incorrect, okay, and you are sure about it, you will be able to answer this question. Third is incorrect, it means you can eliminate option third, you can eliminate this one, you can eliminate this one, you can eliminate this one. So B, C and D, all these 3 statements are eliminated. You are left with the correct answer, that is option A, 1 and 2, okay. So this question is specific for those people who know about elimination method, because, like, they will be able to arrive at the answer even without knowing the factual details of these 2 statements, okay. These 2 statements are correct, okay. So with this, the correct answer for this question is option A, 1 and 2, means these 2 statements are correct. Means the Parliament Prevention of Disqualification Act 1959 exempts several posts from disqualification on the ground of office of profit, and these posts include, you know, parliamentarians. These posts includes, you know, vice chancellor of universities, means, like, various posts are there, okay, that are included, and the officers of the NCC, National Cadet Corps, like that, okay. And the above mentioned act was amended 5 times, okay. So this particular act was amended, okay, in the year of 1960, okay, 1992, 1993, okay, 1993, 2006, etc., okay, like that. So this particular act was amended multiple times, okay, 5 times. It was actually amended 5 times, okay. That's the thing. So having understood this, now let us take the next question for the day. Okay. So this question is a good question. I mean, I would say, like, it is one of the good question. If you just know about, you know, the 9th schedule of the Constitution of India, or you know about Article 31A and 31B of the fundamental rights, you will be able to answer this question. Let us read this question. It was asked by UPSC in the year of 2018, okay. So let us read the question. Consider the following statements. The Parliament of India can place a particular law in the 9th schedule of the Constitution of India? Definitely the Parliament of India can place a particular law in the 9th schedule. You might have read in your textbook, if you are reading Lakshmikant or you are reading D.D. Basu, or you are reading any other book, so it is clearly mentioned in those books that the Parliament of India can place a particular law in the 9th schedule of the Constitution of India. And the Parliament of India places laws in the 9th schedule under Article 31A and 31B of the Constitution. And these articles are part of fundamental rights. Okay, these are part of fundamental rights, and fundamental rights are mentioned in part 3 of the Constitution. Okay, and the articles include article number 12 to article number 35. Okay, so this includes fundamental rights. Okay, so why did the government of India came up with this particular provision that like a law that can be inserted in 9th schedule of the Constitution of India will be immune from judicial scrutiny? Because like in the first amendment of the Constitution of India, when the Constitution of India was enacted, there were various provisions, and government of India has come up with laws so that like they can promote the agricultural sector. And at that point of time, there were many cases that were filed against the government of India. So like it was derailing the process of implementation of those laws. So that's why the Parliament of India has come up with the First Amendment Act of the Constitution in 1951. And in that particular Amendment Act, the Parliament of India made that like that those things that are included in the 9th schedule through Article 31A and 31B of the Constitution, they will be immune from judicial scrutiny. Okay, so this thing was true for long time. Okay, until there was a case in I.R. Coelho. Okay, case. So I'll talk about that thing. First statement is right. Okay, now let us read the second statement. It says the validity of a law placed in the 9th schedule cannot be examined by any court and no judgment can be made on it. Okay, this statement was particularly true till the year of 2007. Okay, it was true till the year of 2007. But after 2007, the Supreme Court of India has given a judgment, and in that judgment, okay, what was the name of that judgment? The name of judgment is I.R. Coelho. Okay, the name of judgment is I.R. Coelho versus State of Tamil Nadu. Okay, versus State of Tamil Nadu. Okay, so in this particular judgment, the Supreme Court of India has said like this was true. I mean laws could not be reviewed by the courts, but now after a particular date, this will be all the things that are placed in the 9th schedule of the Constitution of India will not be immune from judicial scrutiny. Okay, so judiciary will be able to scrutinize those laws, and judiciary will be able to try those things. Okay, after a particular date. What was that date? It was 24th of April 1973. Okay, it was 24th of April, and this case was heard by Supreme Court of India in the year of 2007. So that date was 24th of April 1973. Okay, so what has happened in 24th of April 1973? In that particular date, the Supreme Court of India has given a sea-changing judgment that talks about Keshwananda Bharati case. And in the Keshwananda Bharati case, the Supreme Court of India has given a new doctrine. Okay, that doctrine was known as principle or doctrine of basic structure. Okay, so the Supreme Court of India has like under the doctrine of basic structure, the Parliament of India can amend any part of the Constitution of India, provided that they do not alter the basic structure of the Constitution. And at the same time, the Supreme Court of India did not like define what constitutes the basic structure. So with subsequent verdict of the Supreme Court of India and the High Courts, the doctrine of basic structure has assumed elaborate details, means like many things are being included in the doctrine of basic structure. So the thing is, like, Supreme Court of India has said in the IR Coelho versus State of Tamil Nadu case in 2007 that like all the legislations, all the things that are placed under the 9th schedule of the Constitution of India is immune until this particular date, 24th of April 1973. But all these things that have been included after this particular date in the 9th schedule, they will be open to judicial scrutiny, and the judiciary can review a law that are included in it. Okay, so and this particular date is with reference to the Keshwanand Bharati case. Okay, Keshwanand Bharati case, where the Supreme Court of India has elaborately discussed about the doctrine of basic structure of the Constitution of India. Okay, so this was the first time that the judiciary has come up with this particular principle, and still this particular principle is being used by the courts, and this is one of the most widely used principle by the judiciary. Okay, so that's why second statement is incorrect, because after this particular date, all the laws or subject matters that are included in the 9th schedule of the Constitution of India will be open for judicial scrutiny. Okay, so that's why second statement is incorrect. Here in this question we have to find out the correct answer. So correct answer is option A only, 1 only. Okay, so with this we have come to the end of discussion for the day. Okay, thank you so much everyone for attending this session. I hope you have a good day ahead.
Contact us to avail the combo offer of General Studies and Public Administration optional with 20% discount.